Hello, and welcome to May It Please the Court, discussion of oral arguments during the COVID-19 times. My name is Kelly Woodruff. I am a member of the Committee on Appellate Courts of the California Lawyers Association. And today I will be interviewing Charles Johnson, the clerk of the First District Court of Appeal. Charles, thank you so much for being with us this morning. I know you're very busy right now. How are you doing?
I'm doing well. It's a pleasure to be here.
Wonderful. Well, thank you so much for giving us your time. I wanted to start with the shelter in order places that started this whole thing. The orders started in California. They started in mid-March, and Division 2 had oral arguments set the week of March 18th. How did the shutdown and the shelter in place affect those arguments?
Our court has actually been pretty aggressive in trying to move to remote operations and have as few people at the courthouses as possible. And we started that process before the shelter in place order came out. And once it did, we were very aggressive in trying to pare down our operations at the court. So in very quick order, in mid-March, we had as few as 3 or 4 people at the courthouse any given day running the operations of the court. Some IT people, deputy clerks in the clerk's office, and Justice Humes and Beth Robbins and I were kind of alternating days we would come in.
That's wonderful. Did the arguments that were set for the week of March 18th actually go forward, or were they vacated or postponed?
They did not. They were postponed, and the court issued an order on March 16th saying that for the duration of this emergency, oral argument would be telephonic, and so but we had to work out what telephonic was going to be, how that was all going to work. And so no oral argument was held for the rest of March, and we didn't actually hold oral argument until Division 1 held argument on April 20th. And the week of April 20th, we had 4 different divisions have oral argument that week, telephonically, remotely, with no one in the courtroom, counsel calling in from wherever they called in from, and our justices calling in either from their chambers or more commonly from home.
With regard to those, how did those telephonic arguments work? I know each district is sort of using its own system, and that's part of why we're conducting these interviews. And I understand in the first district, you had lawyers call into a central number. Is that how it worked?
Yes, we used Court Call, which is a vendor that is very commonly used in the superior courts and had been used for telephonic oral argument by some of the other districts at the appellate level. The 2nd District and the 5th District had been using Court Call when they needed telephonic oral argument periodically. And that was great because it took some of the administrative burden off of our deputy clerks and allowed them to concentrate on what they normally concentrate on before and during oral argument. And yes, attorneys would make a reservation with Court Call once we had set oral argument, and they would then, 5 or 10 minutes before oral argument was to commence, they would call in to Court Call and be placed in the proper courtroom for oral argument.
Would that allow the parties and the counsel to sit and listen to other arguments that were not their particular case?
Yes, they could. They were put in the courtroom, but on a muted line. So they couldn't talk, or if they did inadvertently talk to a family member at home, it wouldn't be picked up during oral argument. And then it was just a matter of sequencing. As the presiding justice called the next case, Court Call would take care of muting the folks who were on the first case and making live the folks who were going to argue the second case.
Okay, that's terrific. Now, when you and I just spoke earlier, you mentioned that the First District is processing in the process of moving to video argument in sometime in the May calendar. Can you tell me a little bit about that?
Right, that's our intention. I polled our own justices, and they were overwhelmingly in favor of video argument. And the sense I get from the bar is that they would prefer video oral argument. There's something to be said for seeing the body language or demeanor. If you're counsel, you want to see what the justices, their expression as you make your argument. If you're the justice, you want to see the demeanor of the counsel making the argument as they respond to your questions. And then the sense was that although audio telephonic oral arguments worked really well for us, there was a sense that video oral argument would lessen the chance that someone might step on someone else, might talk over someone else, because you would be able to see that facial expression or the interactions in that way.
Will counsel going forward still have the opportunity to participate telephonically through court call or otherwise if they don't have the capability to do video?
Yeah, obviously the goal here is to make oral argument available to counsel or to parties who are appearing, as pro pers, and so audio telephonic will be an option going forward as well.
Okay, wonderful.
And of course, the other important component in that is whatever system we use for video will be like our telephonic oral argument, in that there will be a number the public can call into, or a link in the video case that the public can use, so that they may view oral argument as it occurs. Because we have an obligation to have a public oral argument, even though we're not using the courtroom.
Oh, it's wonderful. So a member of the public, if they wanted to listen in to an interesting case, they would also have the option of watching visually, participating in the visual aspect of the argument?
Right, they would be able to see the stream of the video oral argument, and the image they would see would be much like the image that those who are participating in the oral argument would see. And we've all seen it on Zoom or Teams or whatever, the 6 or 7 boxes, each with a head in it.
Do you know what software program the court will be using for video arguments, or are you still testing out different systems?
We don't yet. We're still testing some things out, and in conversations with a couple of vendors. We're getting a great deal of really good help from the Judicial Council staff's IT group, who have contacts and in some cases contracts with providers that we might be able to take advantage of. So we're still working out the mechanics about which particular software we'll use, but I think for counsel and for the public and for our own justices, the experience will be much like what you saw with the Supreme Court during the first week of April when they had oral argument, or what you might see at some of the appellate courts that already have video oral argument.
So along those lines, are there going to be opportunities, particularly for the first months of video calendar, assuming that this goes forward for a little bit, for the council to test the systems beforehand and see how it works? Or
we're going to try to do that because it's in our interest too. We want everything to go smoothly. So the goal will be to do that, particularly I think in the beginning, because we'll want counsel to be comfortable, make sure that whatever system they're using from home is going to work and be compatible, that they'll be heard and seen. And our justices will want to get comfortable with whatever system we're using as well. We're a little different from the Supreme Court in that we have oral argument 10 days a month. So squeezing in rehearsals, practices, testing is going to be a bigger lift, but it's our goal to do that. Yeah.
Wonderful. I'm sure, especially for the first round, for each particular attorney's argument, that will be appreciated, because there always seem to be some unanticipated hiccups, as we know.
Right. I think what's going to be key, and what the Supreme Court found out when they did this, for example, is that whatever system an attorney who's arguing, whatever system they use on that test, if it works well, they need to be sure that's the same system they're using the day of oral argument. Don't use a system at your office for the test and then use the phone system only to find that something's wrong and you have to press your teenage daughter into helping you fix it.
We've all pressed our teenagers into
That's my IT
at
skill
various
too.
points. So also, I guess maybe you've already answered this question, but so if there are multiple arguments in a day, and say my argument is the 4th on the calendar that particular morning, I'm able to still sort of dial in and participate in the video conference to watch the other arguments first.
You can. If it's a particularly long calendar, it's possible that the division, when noticing oral argument, will tell you to not call in at 9, but maybe to call in at 10 a.m. if they anticipate that your case isn't coming up till 10:15 or 10:30. That doesn't mean you can't call in earlier, but for example, Division 5 had oral argument last week, and they had a long calendar, including an afternoon session after lunch. Well, it makes no sense for someone to call in at 9 for that, so they staggered their notices and let people know with some reasonable accuracy when they needed to call in.
All right. And what are you anticipating will be sort of the visual that both the justices and the attorneys will see? Will it be similar to this conversation we're having, where the attorney arguing will see all 3 justices and the justice will see the attorney?
Yes, the attorney will definitely see all 3 justices. I think the most likely outcome is a mosaic where the 3 justices on the panel are visible, and where both counsel, if it's 2, if it's more, there might be more, will also be visible, including counsel that is not speaking at the moment but waiting their turn.
I think that could be helpful. Do you have any tips for what lawyers could best do to present themselves in a way that's clear and actually helpful to the justices?
Right. Well, I think the things they would normally do in courtroom apply here to some extent. You know, they'll be able to see everyone. So I think the key is to appreciate the fact that
Charles, 1 minute. Sorry, I need to stop you. I got some interference there.
Okay.
Some loud interference. Can you start the answer to that again?
Okay, and I think the important thing there is that the attorneys realize that it's still oral argument, and that they need to do some of the same things they would do in the courtroom. They need to appreciate that the justices have read the briefs and are familiar with the record. And so the attorneys need to do what they would do in the courtroom, which is to concentrate on the most important parts of their argument. And try to address those points, and expect that the justices will have questions about those points. I think trying to make sure that whatever system you're using from home is fairly up to date, and that you're able to have the audio and video work well on your end, so that you're able to see everything and hear everything is important.
Okay, thank you. How have the justices responded to remote arguments in general? Do they like it? Do they wish more people would just opt out?
I think they like it. I think nothing replaces being in the actual courtroom, but I think the telephonic oral arguments we had last week went very well. There were perhaps a couple of audio glitches where things weren't perfect. That's to be expected sometimes, I think. The justices were very careful about identifying themselves before they spoke to counsel with a question, which I think is very helpful for counsel and maybe less necessary when we're doing video. So they adapted pretty well to it, and I think we'll be even more comfortable with it in the next 2 weeks or so that we're using it.
That is good to know. Do you think that this experience has opened up the possibility that the justices and the parties will be open to doing some type of video oral arguments moving forward, even after we come out the other side?
I think potentially that's true. I think once we come out on the other side and have normal again, actually, I think the justices, the deputy clerks, the CHP, counsel are all going to be quite glad to walk back into a real courtroom. And that will give everyone a sense of normal and a sense of security. But, having said
Another
be
glitch.
closed again.
Sorry, there was another glitch. So it froze up. Sorry, after having said that, and I'll try to edit this out if I'm able.
Yeah, that's fine. So I think that there might be more times when counsel requests video argument or requests audio argument, particularly if they're traveling long distances, and particularly if air travel, for example, or travel generally is one of those things that is slower to return to normal than our workaday lives.
Certainly. I know there's been a lot of discussion about in the bar about how this opens up a realm of possibilities for access for people who may suffer from physical disabilities or hearing or visual disabilities as well, that this could maybe be a very good thing for some of those people in providing more access too. So it's going to be interesting to watch how this plays out.
I think you're absolutely right about that.
All right. Two more questions. One is, have you noticed, or maybe it's, excuse me, too soon to tell, but have you noticed whether people are waiving oral argument more than they otherwise were under normal circumstances?
Surprisingly, I don't think they have. I think they're not deterred, and they want to make their case. So I expected to see more people waiving oral argument than actually have. It hasn't been an increase.
Okay, well, that's interesting. Do you have any parting thoughts for the members of our bar as to conducting oral argument in the First District?
I just go back to what I said before. It's oral argument as it would happen in a courtroom. It's just happening with a different medium. And so the important fundamentals to remember are the same ones you would take into the courtroom.
That's wonderful. I know there are some blogs going around already reminding people, no pajamas, and
I think there's a video going around somewhere of some person in Florida making an argument in their PJs.
Exactly.
And I put on a tie for this. I don't know if you really do that at home.
Exactly. Well, I very much appreciate your being here with us today and helping us to get the word out to the bar for any help that people can have to conduct effective oral arguments that are actually helpful for the justices is greatly appreciated.
Oh, I'm happy to do it. My pleasure.
Well, thank you.